the Mental Capacity Act that was passed in 2005, came into force in 2007, took over the jurisdiction of what was then the High Court. Before the Mental Capacity Act, we had enduring powers of attorney, EPAs, that dealt with people's finances. And then in terms of health and welfare, any disputes around health and welfare would tend to be determined in the High Court using the inherent jurisdiction. When the Mental Capacity Act came into force, one of the brand new inventions, if you like, of the MCA was this health and welfare lasting power of attorney. So that was the first time in English law that we could appoint someone else to make decisions around where we live, to make decisions around life-saving treatment, to make other forms of healthcare decisions. It was quite a novel invention in the Mental Capacity Act. So that was brand new. And then alongside that, we had the finance and property LPAs. And so having two LPAs basically reflects the two dimensions of the Mental Capacity Act, in essence. And you'll see that throughout the Mental Capacity Act. The Court of Protection used to deal with finance. It now deals with both finance and health and welfare. LPAs or EPAs used to deal with finance. Now LPAs deal with both. We also have what's called deputyship, which is when someone has not planned ahead with an LPA, but we need someone installed by the court to make best interest decisions. And again, you've got two types of deputyship. One is for health and welfare, the other is for finance, although most people are appointed to deal with finances. And so that's a common theme really throughout the Mental Capacity Act, that it has these basically two dimensions to your life. Everyone has issues around their finances and property, and then there are issues around your health and welfare. And we simply have two LPAs to cater for either one. Under the Mental Capacity Act, there are various ways in which you and I can plan ahead for the worst case scenario, where we might be unable to make a decision. And don't forget, incapacity could be caused at any time. A lot of people that set up lasting powers of attorney do so after they've received a diagnosis of dementia. But LPAs can be set up by any of us. And the lasting power of attorney is one way of planning ahead, and there are two types. So you have an LPA for health and welfare, and quite separate to that, you have a lasting power of attorney for property and financial affairs. And so LPAs are a very useful way for families to entrust to someone that they do trust the power, whether it's financial or health and welfare, the power to make best interest decisions for them in the event that they can't decide for themselves. And to some extent, LPAs are a more regulated scheme of safeguards than what we used to have. We used to have what's called an enduring power of attorney. So LPAs are more regulated than that, in the sense that, for example, they have to be registered upfront by the public guardian before they can be used. And the public guardian has an important supervisory function. If, for example, there are concerns as to whether an attorney is acting in the person's best interests or not, potentially financial abuse, those sorts of issues can be raised with the public guardian, who sometimes will investigate that alleged abuse. Now, it's very common for people to appoint a family member under a lasting power of attorney. And it's not at all uncommon for that family member to potentially also be a beneficiary under the person's will. And there's nothing wrong with that. It's absolutely fine for someone to be an LPA in the knowledge that they could receive inheritance after the person passes away. I, for example, was my grand's power of attorney for both health and welfare and finance. And I'm also a beneficiary under her will. So that's a very common state of affairs. And as an attorney, you always have to decide on the other person's behalf what is in their best interests. And so attorneys, family members are required, most of them don't actually know about this, but they are required to follow the code of practice to the Mental Capacity Act and to decide what is best. And I think generally it works absolutely fine. I think families are very well placed to make financial decisions, pay people's care home fees. You can make gifts, customary gifts, under the LPA. And I think generally that works well. But you do have cases of serious financial abuse. There are ways of dealing with that. So any financial abuse that's suspected needs to be flagged up. The local authority could investigate, the public guardian could investigate, and ultimately, if it's proven that the attorney is not acting in best interests, then the Court of Protection has the power to revoke, to take away that power of attorney in order to protect the protected person that set it up in the first place. One question that sometimes gets asked is, well, if someone set up a lasting power of attorney, how is it revoked? And in essence, revocation involves making an application to the Court of Protection, and then the judge will decide whether to revoke it. And usually there are two main grounds for revoking a lasting power of attorney. The first, which is not often relied upon, is demonstrating that the person actually lacked capacity to set it up in the first place. And so you do sometimes have cases where family members have organised for a person with dementia to set up an LPA when it was actually quite clear at the time that they didn't have the capacity to do so. Now that should have been picked up at the time, but sometimes it isn't. So if the person lacks capacity to set up an LPA, that can be a ground for revocation. There is also another ground for revoking an LPA, and this is more common. And so if, let's say, a family member is not acting in the person's best interests, and if that can be proven, and often having to prove it is the challenge, but if you can prove, and it's often local authorities that are involved here, if a local authority proves that the person is not acting, let's say, in the person's financial best interests, maybe there is evidence of financial abuse, maybe they've been taking the person's money and spending it inappropriately on themselves, for example, then the local authority or the public guardian can make an application to the Court of Protection. And if the court is satisfied that the person is not acting in best interests, because of course that's the role of an attorney to act in best interests, if they're not doing so, then that provides grounds for the court to revoke the LPA. And then, of course, if it is revoked, the court will have to decide what to do then. And it might be, in a financial case, if there's still a substantial amount of money at stake, they might look to appoint a financial deputy.